Welcome, ladies and gentlemen, to Collier Bristow's US-UK podcast, a series which sheds light on some of the most common aspects of US-UK cross-border planning. We're looking today at the rather cheery topic of will planning, something that no one wants to think about, and yet which everyone should. I have the great pleasure today to be joined by Chris McLemore, a partner at McLemore Konschnik LLP, a boutique US law firm practicing here in London and specializing in tax trusts and estate planning for Americans in the UK. Chris has been practicing in the UK now, he might correct me, for around 15 years on exactly the sorts of issues that arise in this field. And so I can think of no one more suited or better qualified to have this discussion with me today. Chris, thank you so much for joining me. How are you today?
I'm very well. Thanks, Aidan, for having me. You're exactly right. 15 years in London. And for all that time, I still haven't lost my very American accent.
It would be a tragedy to both the American and the British communities if you did. So I mentioned that we're going to be looking at will planning today, and it's going to touch on a number of different topics. We're going to be looking at why you should be thinking about will planning and what are the occasions that might give rise to you thinking about will planning. So, trying to give you some tips. If you're thinking about making a will and you're listening to this podcast, hopefully you're already on the first step. We're then going to look at the question of how many wills someone should make. Sometimes for some clients, they should be thinking about making a will in both the US and the UK. Sometimes clients can get away with both, with a will in one jurisdiction. And Chris and I will talk about some of the factors that go into thinking about that issue. We'll then think about the form of wills, and particularly for those, I'm going to sort of use as a shorthand, Americans living here in the UK, those who have both US and UK tax and non-tax issues to think about. What are the sorts of wills that someone will typically make, and what are the main driving factors that determine what sort of will an individual makes? And then we'll at the end go on to probably the meatiest and most interesting part of the discussion, which is thinking about, well, what are the tax efficiencies that could be generated by an appropriate form of will planning, and why should someone, particularly an American living in the UK, for example, why should they think very carefully about their will planning and seek specialist advice from people such as those at McLemore Konschnik to make sure that their will is as tax efficient in both jurisdictions. So, on that note, let's start thinking about will planning in its broadest sense. Chris, if someone comes to you and says, why should I think about making a will, or when should I start thinking about making a will? What are the kind of things you're saying to them right at the very beginning?
Well, I think when people think about wills, sometimes, my mind often goes to tax, because that's where much of the work has to be done when you've got somebody who's a U.S. citizen living in the UK and potentially married to a non-American as well. My gears start turning thinking about tax, but individuals, who aren't preparing these documents day in, day out, think about wills really about documents that get rid of their assets and give them to the right people in the right form at the right time. I think that's a really important thing. But another thing that I think is incredibly important about wills, and is often the thing that gets people motivated to do them in the first place, is things like appointment of guardians if you have minor children. That's something you can do outside of a will context, but is most commonly done with a will. So when somebody says to me, do I need a will? I think, the first question is, do you have children? If the answer is yes, then I think the answer to the question is yes, you absolutely need a will. Not only to appoint the guardians, although I think that's massively important, but also then to make sure that if you have assets, whether large or small, they go to your children or other beneficiaries, in the right form. And so that starts people's minds turning. But even if you don't have children, or your children are above the age of 18, so guardianship isn't an issue. Anytime you have assets split across two jurisdictions, the will is going to be an important document to start your estate administration off on the right foot. Because, in essence, if you don't have a will, you do have a will, but it's just the intestacy laws of the various jurisdictions where you have assets. And intestacy is just how jurisdictions push assets in the absence of wills, right? And it might be obvious to the spouse and then to the children. But in some cases, that's not exactly how it will go. And if you've got assets across a number of jurisdictions, so here we're thinking US, UK, doing intestacy in more than one place is even worse. But I think it's also important to note that the US isn't just one jurisdiction, it's 50 different jurisdictions. So in a worst case scenario, even the most straightforward of American who's here in the UK might have property in the UK and a bank account in New York in a family, a vacation home, even of modest size, a cabin on the lake that they own a third interest in with their siblings in Vermont, and maybe, some residual property in Florida for when they had a secondment there. You're looking at 4 jurisdictions, no will to speak of. And that has what it, from very simple means, become a very difficult situation to administer. So you're leaving executors and family members with a lot to unravel.
Yeah,
so I think
I think it's peace of mind is really what you're bringing. You are taking the steps at the beginning to put your affairs in order, so that at what is undoubtedly a tragic time, at your passing, your heirs are, they can be assured that you thought about what should happen first, and you've taken the appropriate advice, so that everything can be administered in as efficient a way as possible, not even as tax efficient a way as possible. Exactly as you say, leaving things up to the intestacy rules is to chance fate as to making sure that your wishes will otherwise accord with the intestacy rules. But also, you're then going through the process of trying to deal with separate pieces of administration in separate jurisdictions, whether internally in the US or between 2 different countries. And so there is never a bad time to be thinking about will planning. We sometimes say, significant life events, when it has a child, when someone is married, particularly when someone is married, because certainly in the UK, marriage revokes all previous wills. When a parent passes, those are significant triggers that should make someone think about their own planning. But even still, every 5 to 10 years, if you have a will, you shouldn't necessarily think, well, I'm afraid it's done and I don't need to think about it again. Rules change, habits change. The child that you had that was 6 years old when you made your will 10 years ago is 16 years old now, and in 10 years' time will be 26 years old. And your planning from an asset protection perspective, from a taxation perspective, is going to change over the course of those 3 events, let alone the tax rules might have changed across those 3 events. And it only takes the rules to change in either one jurisdiction or the other when you're thinking about cross-border planning for suddenly that plan to lose its efficiency. Chris and I will come on to discuss some of the ways in which, for example, the American regime has changed in the last 10 years quite significantly, not least because of the way in which the allowances have changed. And that can cause, some people to fall into tax that weren't previously, and lots more people to fall outside of tax that were previously. And that will then cause you to think about will planning in perhaps a slightly more dynamic sense, or to make you think about it in a slightly more relaxed sense. But it's individual to each client. And so we would always recommend, the first step is having the discussion, is opening the line of communication, and we can tell you where you think you fall and what it is we think you might like to think about doing.
Yeah, it's such a cliche to say the best time to have prepared a will is yesterday, and the next best time is today. But, with so many things, that's absolutely true. Clients will say, well, I know the U.S. exemption is quite large, and we'll talk about this later, but it's $12 million US, so I'm not exposed to estate tax. True, the exemption is large, but that doesn't have anything to do with whether or not it would be appropriate for your child to receive cash and assets outright or in trust. Sometimes we let the tax, and especially the generous exemption, govern whether or not it's appropriate to make a will, but it's always appropriate to make a will to dispose of your assets. And if they are modest, you still need a will. It might not be the all singing, all dancing will that we might do for a different client, but it's such a cornerstone of family planning. And to think that you're leaving up decisions about how your children receive assets. I think when people don't like to consider these issues, but if you think the will is really only ever going to matter upon your demise. And so if you think about that in real terms, you've died, potentially your spouse has predeceased you, died contemporaneously. What state will your children be in? What will their personal circumstances be? Would it be appropriate to receive a load of cash outright, access to pensions, whatever those things are. And are there people you would like to be, there to guide them through that process, and not necessarily even in a formal capacity, but people who should be available to help out, who might get a mention in a letter of wishes, which again is something we can talk about later on. So you're doing so much more than just dealing with tax. You're doing so much more than just saying my watch goes to my son, and I want $10,000 to go to the donkey sanctuary. Both of those things might be really meaningful, but the document is going to do a lot more work when it's actually called into action.
So that neatly takes us on to, I think, the second point. You talk, Chris, about the document coming into action. Sometimes it's more than one document. So there are certain circumstances where our clients may be thinking, and it's one of probably the most common questions I get from an American who approaches my law firm first is, I'm concerned I need to make two different wills. I need to make a will in the UK for my UK assets, and I need to make a will in the US for my US assets. The short answer to which is, it somewhat depends. And, peeking behind the veil, Chris and I have had several discussions plenty of times about, what do you think about this client? Do you think this client should have one will? Do you think this client should have two wills? Because there are clients that are on the edge or the watershed of that discussion, and you could make an argument both ways. From my perspective in the UK, we have spoken on previous podcasts about the differing opinions to probate in the US and the UK. And certainly from a UK perspective, the probate system is not one to be feared. It's one that everyone goes through and everyone sort of respects and understands. It's not that costly and it's not that time consuming. The probate process in the US is one that is fraught with complexity. I think it's fair to summarize it in that way. So we're thinking about probate when we're thinking really about two different wills. We're not thinking about tax efficiency because the tax codes will respect wills from other jurisdictions. What we're really thinking about, and certainly the way I characterize it to individuals who approach us, is with two separate wills, you can in effect start two different probate processes. You can take the UK will and pass it through the UK probate, and you can process and take the US will and do the same there. And so you can run two different probates simultaneously. With one will, it does, as a downside, mean that you usually end up doing one probate process, taking your grant of probate in jurisdiction one and taking it across to the second jurisdiction and trying to claim a grant of probate there, which makes that whole process slightly longer. However, with one will, it means you have one singular document that governs everything. You run the risk of one of the documents getting lost, one of the documents getting revoked, one of the documents getting overridden inadvertently. So it's there's no one size fits all. Sometimes it is about tax planning, but sometimes it's just simply about that administration process. How does that work with your clients, Chris?
Well, the good thing is here we're talking about estate planning in a US-UK setting, right? So we're not involving other jurisdictions, and certainly not involving any civil law jurisdictions, on the continent, which could move the needle one way or the other.
Absolutely.
I think what we need to realize is that U.S. probate law is just UK probate law that we stole in around the mid 1800s and then modestly revised over time. The foundation is fundamentally the same. So it is completely possible to take a UK will and probate it in a U.S. court on the assumption that it was signed with the necessary formalities, and vice versa. And I think it's just obvious that having one document would be easier from a management perspective. But this really is one of those questions that will have a different answer, for every individual client case. And I know it sounds like a lawyerly thing to say that it depends, but we'll give some certainty to other questions later. To this one, I think you can't give certainty. Some people like the ease of having one document. They don't want to have to worry about inadvertently revoking a document if they revise the UK will in the future, accidentally revoking the US document. Anytime they want to make a change to the documents, revising two documents at the same time. So there might be some reasons that motivate a client in that way. Another reason that you might have two documents is so that you can start probate contemporaneously in both jurisdictions. So have the US document and the UK document going through probate at the same time, which, as you say, buys you a little bit of time so that the assets are getting administered and you don't have to wait for one country before you move to the other. But it also depends on the nature of the assets, right? Sometimes clients will say, I need a US will to cover my US assets. But actually, the US assets are a pension and a piece of property that they own jointly with their spouse. Well, jointly owned property is what we call a non-probate asset. It passes to the joint tenant automatically on death. So even if the will said, I give all my interest in our property in Vermont to Aidan Grant, it wouldn't pass to you because it would go to the joint tenant. Pensions and most retirement accounts are also non-probate assets. They pass by way of beneficiary designation. So it might be that you don't even have any assets in the US or the UK, one country or the other, that's going to pass pursuant to a will, which again speaks in favor of having just the one document. So I appreciate that that's not a clear answer, but there isn't a clear answer that will cut across all circumstances, and it could change. My slight preference is to have one document because it makes getting the tax correct a bit easier than trying to do it across two documents. But depending on the client's circumstances, I can easily be moved, and we're very happy to take the approach really in either direction.
I mean, I would sort of only finish that with two other points. One is to your point, Chris, about the one document and the taxation. Just to sort of reassure anyone that's listening to this, there's not necessarily any specific cost saving to doing either one will or two wills, because in a properly cross-border context, even if there are two separate documents, that's not to say that Chris is drafting one document and I'm drafting the other, because there can still be tax consequences that flow from each document in the other jurisdiction. And so you still want your lawyers to each look at both documents. The effect is really as a drafting exercise, whether you try and combine those two documents into one single document, or whether you separate out the complexity and have two separate threads running alongside each other at the same time. So it really does depend on each circumstance. When it comes to, well, this is fine, but neither of these two lawyers has actually given me an answer to a question at least a question I can start with. Plus a change, you might think. The general position I start with, if we're doing one jurisdiction, then of course the answer is in which jurisdiction. That's the next question. I generally start with, where are you right now? Where are your inheriting heirs? And where are most of the assets, or rather, where is most of the tax going to fall? Where should from which jurisdiction's tax rules is the estate planning being governed? And that's the answer to those three questions is what tends to drive with one will, in which jurisdiction does that will sit? So if you are an American citizen living in the UK, you are a deemed UK domiciliary, your UK home is in the UK, your kids are in the UK, then the answer is going to be, if it's one will, it's going to be a will based in the UK, realistically, unless you are worth significant sums of money where US taxation is a real threat because your combined wealth is over $12 million or $24 million if you're a married couple, both of whom are American, in which case we might be reverting back to the US will at the same time. By comparison, if you're one of Chris's clients based in, say, New York, and you happen to have a UK bank account, I'm going to be saying, well, I think it should probably start in the US. And if your assets grow sufficiently large where they requires the presence for a separate UK will, then we'll do a second will in the UK. But it always usually starts from one jurisdiction or the other and then grows across as and when the time calls for it.
Yeah, I think the other thing to bear in mind when people say, where should my will be, is that if we think about really how testamentary law works in both countries, if I were to sit down right now and write on a blank piece of paper, when I die, I want everything to go to these two charities, the remainder to my spouse and then my kids, and I signed it in my hand in front of two witnesses, and I meet the other testamentary formalities, i.e. I can speak English, I'm over the age of 18 and I'm compos mentis, that would be a valid testamentary document in the state of New York. That would, I think, and you'll correct me if I'm wrong, be a valid testamentary document in the United Kingdom. So, but it doesn't, the document doesn't say anything about governing law. It says, give my painting, to my cousin. But there's no reference to New York, there's no reference to the UK, et cetera. So at its very base, a will isn't necessarily even jurisdictionally specific. Now, obviously, the documents we're drafting are more complex than that. But sometimes the question, where is my will based, doesn't really have an answer. I think the other thing to think about is when sometimes people will come and say, I need two wills. That might be true, but that's really a solution looking for a problem. You would never, if you are, engaging in a contract issue and you need a contract drawn up, for a business or an enterprise you're undertaking, you would never come to the table and say, I need a 3-page long document. You might get a 3-page long document, but that's just an outcome that will be a consequence of your circumstances. The same thing is true with your wills. You might get 2 wills. You might get 1. It won't be because you came to the table asking for 2. It will come because that is, on balance, the right outcome based on your assets, based on your personal values and based on what you're trying to achieve.
If anyone wants to, is feeling particularly an anorak and wants to go away and learn more about the validity of UK wills, we have a wealth of case law that dates back to the early 1800s on what counts as valid wills, because the Wills Act is still the Act of Parliament that we base our will validity on here, and that was from the 1830s. So we've got lots of history of this, and the most famous case that you will hear lots of people talk about is the case where an individual wrote their will on the side of an egg. I believe they still have the egg in the probate registry in the UK. It was a valid document. The fact that they've written on an egg doesn't mean that it wasn't valid. So yes, you're right. I mean, I'm not recommending people create wills on the side of eggs. But Chris is right. The requirements needn't be complicated. And indeed, it is the case. And I'm sure the legal industry in both jurisdictions would say that, generally speaking, we wish more people would have wills, and don't be put off making a will because you think it's complex and difficult. There are good high street vendors you can go to and grab a will off of the shelf and sign it, and that afternoon you have a will in place. Fantastic. It might not be as tax efficient. It might not do all the things that you want it to do, but it will at least be effective, and that is better than nothing. I think we would generally agree on that. However, if you're listening to this podcast or you found this podcast somehow, the odds are you probably want something a little more sophisticated than that. So by all means, make the WH Smith stopgap if you want. But we would still recommend that you come and speak to us. Other vendors of high street wills are also available. When we come back, I'm going to pick up the second 2 points with Chris for our discussion today. Firstly, on what the driving factors are that decide what form of will our clients make, and secondly, thinking about tax efficiency. So join us next time.